All right, I'm going to start the recording because by the time we get started, it will be officially 9 o'clock. We are recording. All right, we are officially publicly deliberating case 22-152 SPHA, and it's 16807 Ridge Road. This was an appeal of a September 1st, 2022 order of the ALJ denying both a request for special hearing and a request for variance. Special hearing pursuant to 500.7 to allow a non-conforming lot created on 7/6/1961. The variance relief was for a 0.67 acre lot in lieu of the 1 acre requirement pursuant to BCZR section 1A 01.3.B.2. We had actually an in-person hearing for this, which was fantastic. Also, it was much appreciated by the diligent work of Mr. Schmidt and Mr. Milio for them to proffer a lot of the background information, which moved the hearing along for us to get the history of the property, the history of the deeds and things of that sort. So that also was fantastic. So basically we heard some testimony, but also the beginning of the oral arguments and the issues as to whether or not this undersized lot could then be issued a building permit. We also received memorandums from both parties, from Mr. Schmidt and Mr. Milio gave us a fantastic memorandum on a variety of issues, laying out different case law and their arguments as well. Just to break it down as to basically the argument of the petitioners is one of a statutory construction nature, basically looking at the language of BCZR section 1A 01.3.B.2, using the term created for a lot, saying basically you could not create a lot under 1 acre. So there was the argument that a lot was not being created. And then we heard from People's Counsel, of course, who disputed that interpretation, also gave us some other issues concerning a possible merger and things of that sort, and the lack of vesting and its non-compliance with other type of statutory exceptions that might allow this property to be there. Just for background, before we discuss, I'll just throw out there, since a lot of our argument is going to be based on statutory construction, that the zoning regs define a lot of record as a parcel of land with boundaries as recorded in the law of records in Baltimore County on the same date of the zoning regulation which governs its use. And then, of course, Mr. Schmidt was kind enough to provide us with the Webster's definition of created to bringing to existence or to produce. I can say that, we don't get to do it too often these days, but I actually broke out the real binder here of the zoning regs to really get deep into the statutory language of the RC zones and things of that sort, so I could see it for myself. And need to do that more often. I kind of like the books. I guess the new generation doesn't know that they don't even know that they exist, actually. But I always feel better when I have them. Just in general, factually too, we heard very interesting history of the property, of its original tract through the Armacost, and then it was transferred to Krebs, and then it was different parts of it were sold off. And basically after the Krebs and the Martin parcels being made, this parcel was basically made after the conveyances of the Krebs and the Martins. So there we have it. So this is the description we have, there's several houses in this area that originally came from the Armacost, and this being the last little parcel of land that was not developed with a residence. And that's basically why we're here today. Anybody else would like to speak and give some thoughts before I chime in?
No, I'm fine. Thank you, Andy.
All right, Deborah, would you like to speak a bit?
Um, I'll wait till you chime in a little more. I have some thoughts.
Okay, all right. Well, okay. Okay, well, so what I was struggling with, again, I went back and forth for this. Basically, when I was in the hearing, when Mr. Schmidt made his presentation, I was like, that makes absolute sense to me. And then when Mr. Emilio made her presentation, I was like, holy smokes, I didn't think of that. That makes absolute sense to me as well. And then I got the memorandums, and I'm reading one. I was like, yeah, that's the way to go. And then I read the other. I'm like, oh, well, that's the way to go. And the one thing that struck me, about People's Counsel's argument always was, and it hit me at that time, is, if the interpretation is correct by Mr. Schmidt, then, how does property ever get downzoned? How does it even happen? Why, through the CZMP and things of that sort? Would it make any sense for this interpretation? And I thought about that, and then, getting out the book and getting deep into the statutory intent and looking at the mission statement of itself, I started to think, well, what exactly is being done here? So one thing that I'll bring up, that I don't know if either of the arguments itself went over this itself, but I went to section 1A 0.1 is this the general provisions of the RC2, and looking through those general provisions, the declarations of why the legislative statement and findings, and all of those A through G basically deal with the societal ill they were dealing with, was basically agricultural land being divided up in subdivisions. And basically every bit of, not every bit, but a majority of the statements here deal with subdivisions. And I felt that interesting because nowhere in this legislative intent were they talking about, we want to make sure that people don't build a house on an undersized lot. And I say that because I think what they're more concerned about is that we don't have subdivisions, meaning multiple houses with undersized lots, cookie cutter around this agricultural land with these good soils and things of that sort. So that was, trying to get some more definition or clarity about the word created. Looking back at this, is, the ill that they were trying to stop was really not someone building a home on an undersized lot, one lot. It was, subdivisions itself. Looking at statutory construction, I mean, the term created, there's a lot of different words you could have used and a lot of different ways you could have described not permitting a structure from being built. I bring that to issue too, because I was just looking at the RC3. It's a different animal, different time, but I was looking the way the RC3 described lot size when they're doing their height and requirements and things of that sort. And they talk about that you cannot have residential development on lots less than 1 acre. And I thought that was a much more artful way of getting to the root of what they were trying to say. We don't want anything built on anything less than 1 acre. And I was looking through all the different RC zones and different ways that things that were described. And it seems like the RC2 was probably the first crack of the legislative language of trying to figure out what they were going to do. So, I mean, the argument that, well, it doesn't make sense to allow an undersized lot to have a dwelling on it pursuant to RC2 using the term created, I think it could make sense in the fact that, going forward, they didn't want subdivisions with lots less than 1 acre, but they've used the term created to basically say that if it's already there, meaning it's already been created, that it would be allowable. And then I think about, the perceived Armageddon of what's going to happen if you interpret it this way. And I thought, it's somewhat hyperbolous because the facts that we have here are very specific. First we have the creation being prior to, 1975. Just think if 20 years ago, if we had this case, it would be, oh man, that's recent history. That's not too long ago. But as I sit here today, we're almost pushing 50 years since that. So the properties that this would actually apply to in this interpretation becomes more and more finite. So this is a very specific factual determination. And also, that being said, the only thing that's being skirted here is the lot size. The RC2, the rest of the standards do apply. The setbacks, everything still applies. What does not apply is just the actual lot size itself. And then, when I'm looking at the legislative statement here, and I'm thinking to myself, and say 1975 or whatever, they've been terribly troubled to learn that this lot that was already created was going to get a house on it sometime in the RC2 zone. I don't think that would have been the intent and the perceived ill that was being cured. So I don't. And the reason I say that is I just don't think that the interpretation of the term created in the fashion that Mr. Schmidt argues is illogical. I think there is logic to it, but really I don't have to go there because in looking at tenets of statutory construction, created is what it is. It is what it is. You had a million ways to write what you wanted to happen, and they chose the term created. And there's no other reason for it to be there. Again, it would be a superfluous term. It would just be hanging out there. We're not supposed to interpret it. So anyway, I've twisted myself in the wind here, using the statutory interpretation, the plain meaning, and then looking back to the legislative statement, which deals 100% with this subdivisions. I don't think the strict interpretation of this lot, who sits in good company of a bunch of other non-conforming lots, was something that was trying to be prevented. So that's my thought on that. And then to extrapolate this a little bit further, we didn't get into the variance. I don't think we really, it was kind of abandoned by the time it got to us. So, in any event, I don't believe that there was any uniqueness or anything provided for us to go to the variance. So I think we're more concerned with the special hearing. So that's my thought on the matter. I could be persuaded otherwise, since we in fact are deliberating here. So I would love to hear from both of you.
Well, my view is, I looked at it a little differently. My view is the lot was validly created back in the 60s, that remembering the controversy over the adoption of the RC2 zones, I think that the word created was deliberate, not to disenfranchise those lots that were in existence. I also considered that without granting this approval, there's absolutely no good use of the lot for a permitted purpose. And I looked at all that. I also read the cases relied on by People's Council, and I really didn't find particularly the Quinn case very persuasive, because factually it is so different. It dealt with a statute, and even the language of that case said if the statute permitted an isolated undersized lot to be able to obtain a building permit. So it recognized that there were instances where the general rule didn't apply. I also agree with your view of the statutory construction. And I think if we're going to rely on something, it is better to rely on statutory construction than a constitutional argument, just as an approach. So I would tend to, my personal view is that we should approve the special hearing.
Brett, any thoughts, sir?
Yeah, I've got a few thoughts. I jotted these down. And I agree with you, Ms. Topkin. I think this was, I mean, in a practical kind of side of it, and I appreciate your statutory research and thoughts, Andy, but a practical side of it to me is when the subdivision was created, my experience with that type of thing is usually the lot at the end is the shortest one. And everybody else in between kind of is whatever they are, you know, in terms of the size. And this one was next to the end, if you will. And that tells me that it was created basically for a residential property of some sort. That at the time it was there and the intent was to do that. I think Ms. Topkin mentioned the other standards in the district in terms of setback, rear yard, side yard, etc., are met in this proposed housing here. I looked at the lot also as being unusable, and that being something that kind of weighed in for me, and the harm to the area. I mean, I looked at it both, I mean, from a practical kind of standpoint, and came to the conclusion that we should grant this. I mean,
And I wanted to add, I don't think there was a merger. I don't think the issue of vested rights apply. I just didn't find those arguments raised by People's Council pertinent to this factual situation. And I do believe this is a very narrow case, very site specific.
I'll second your thoughts on the merger. Just looking at the testimony we heard about the uses, we didn't hear anything accessory structures, swimming pools, and things of that like. Basically, it was basically a play area, I believe, of folks and kids at different times and things of that sort. So,
Plus, Mr. Schmidt pointed out that other than the lot size, a house can be built here and observe all of the RC2
yes.
bulk regulations. So that also is helpful. And, you know, as to the variance, this lot arguably could be said to have an irregular shape, and there are slopes. They don't pertain to the size issue per se, but if somebody really wanted to strain that interpretation, they could, but I don't think it's relevant to our decision.
all right. Well, we are, I guess, from different avenues, we have all ended up at the same place, I believe. So,
Mhm.
all right. So, in summary, and just for a matter of practicality and a matter of statutory construction and matter of just what seems to be the proper decision in this case. We're going to approve the grant, the special hearing. And I guess probably the cleanest way to do this, why don't we say that since we're approving the petition for special hearing, we'll make the request for the variance this moot at this time and not make a finding on that, even though I think it was pretty much abandoned at our level for the evidence that was placed on the record for that. So, all right, that's how we'll do it. All right, well, thank you both.
Before you leave us, I think this is our last deliberation together.
I think this is my very last one. Knock on for Micah that folks see fit to send me elsewhere. But yeah, I believe this might be my last one.
So thank you for all your service. It's been half your life, or it just feels like it.
All right.
It's been great, Andy. Thank you.
Yeah, thank you, Andy.
All right. Well, thank you both. You guys have a great day.
All right.